All right. According to Mr. Maury, the CPS is no longer involved. They've closed their case. Is that true, Mr. Maury?
Correct. And they both told me to go back to the court ordered
Right.
uh
But I need to know that CPS has closed their case. Miss Maury, did they close their case?
Yes, they did, but CPS also did not fully do their own investigation. They were going based off of law enforcement's lead.
Well, and both have that equal ability to investigate, and therefore parenting time goes back by law to what it was ordered.
Okay, well, I can tell you right now that even though the police and CPS both make it go back to parenting time, the police also told me that there was not enough substantial evidence
Correct.
to take him to court, but
Correct.
that does not mean that he is innocent.
No.
And I'm not going to send my girls
All right,
back to him.
Ma'am, Miss Maury, let me tell you how this is going to run. Okay? The court needs clear and convincing evidence to stop parenting time. Child Protective Services and the police require a very low burden. So the court, by law, has to order that parenting time occur. Okay? I'm not going to hold it against you during the time period that that they were investigating. But if the investigations are closed, they may say he's not innocent, but the law says there is a presumption of innocence, and they don't have the evidence. So yes, by law, parenting time goes back to the way it was ordered.
Okay, I hear you and understand that, but I am not going to send my girls back to him.
If you do not, Mr. Maury, you have the right to apply for parenting time show causes, just as there's show causes for child support. Ma'am, you have to understand that the court will hold you in contempt for noncompliance of a court order.
I do understand that. And since the investigation has been launched and closed, my daughter has been in counseling. Understood. And more has come forward as to what he had been doing to her.
In that case, the counselor needs to alert Child Protective Services that there is more.
She has been making reports, yes, but Child Protective Services thinks it's a joke, and they have told me that it's a Kent County matter, and I have not been able to get in contact with Kent County CPS. No one is wanting to listen to my daughter.
Why is there another county being involved?
Well, I live up here in Clare County, and Spencer lives in Kent County, but it happened down in Kent County.
Right.
Which is where I launched the police investigation.
And that's where Child Protective Services should be doing their investigation.
Nope,
and sir, if it has not been fully investigated, she may be exonerated from contempt. Both of you have your right arguments. What I'm telling you is where the law stands now.
Yeah, so CPS and
I understand that you're gonna have to show that CPS closed those cases because you're gonna need something in writing to hold her in contempt. So you guys are at an impasse right now, and so am I. By law, if they've closed their investigations, it has not been shown that there is a problem for the child. The counselor may have more information, but that's in the counselor's hand. She's a mandatory reporter.
Yeah, then do I have to go down to the courthouse to file that motion?
You can file motions through the Kent County front of the court to work on parenting time and how it should go. They may or may not help you, just as CPS may or may not help her. Like I said, you both are stuck at an impasse right now. If there are more allegations coming out, there may not be an ability to give you parenting time. And new allegations, she has the right to show to the front of the court and show why she's concerned. If she has a justifiable concern for the safety of the child, she has the right to withhold the parenting time. Problem is we don't have any of that paperwork. So I don't have anything showing CPS closed their case, for one. And I do have the note from the counselor, but that's back in August. So, and it was very sketchy. There was no concrete allegation. There was a bald statement that had no background. So that maybe nothing was investigated, or everybody went, well, if the counselor has more, she better alert the proper CPS authorities. And that would be, she would have to contact Kent County. Yes, ma'am.
Just a quick question. I had already filled out the correct forms and everything to release everything to Judge Bryant for the judge to be able to get a hold of the thing that my daughter is going counseling.
The court does not go out and get evidence. We only review evidence brought to the court. No, we don't make phone calls and stuff.
Okay, I have an updated letter from my daughter's counselor. So who do I need to mail that?
You would want to file a motion on your own behalf concerning parenting time with updated information. Right now, the only information that had filed was the letter from the counselor from August stating that there was a problem, and Mr. Maury's motion that says that Child Protective Services and the police stopped their investigations and there would be no charges, and they did not substantiate the underlying allegation.
Okay, so you did not take a look at what I had already mailed down there
The only thing
to
that
Judge Bryant.
the only thing that I received from you is the letter from Community Mental Health. It is not dated. Luckily, the first line says I have been working with the child since August 19th. Does not say when these allegations were made. Okay. This is the only letter the court has received. That's it. Okay. If you're going to act as your own attorney, you have to take the consequences of that happening. You have to file them orders appropriately. Okay.
Okay, well, I will definitely be doing that.
Please do. And maybe the impasse will be gone one way or the other. You both are where the instructions are right now is that if the Child Protective Services investigation is closed, and you have the right also, Ms. Maury, to object to this motion, this order that I'm going to issue. Okay.
Yep, which I do fully object because I do not agree with it whatsoever because the law is not doing anything to protect a 6-year-old girl.
I just tried to explain to you what the law is.
Yeah, and the law is
not always the law is not always correct, but it is the law. But it is the law. And we are all presumed to abide by it. So I've given you instructions both on how to do so. So yeah, at this time, the former orders will be enforced.
I'm just going to say right now that it's not going to be enforced and the girls are not going back down there. I will be filing the correct paperwork to.
Then I suggest you do. This motion is done before you say something more stupid. Have a good morning. You don't look at it. You don't look at a police officer and say, "I'm going to be speeding out of here after you've given me the ticket." Have a good morning.
Sir, I have something to say along with our agreement. In our agreement, it says my pickup time is 11 a.m. I was wondering if you would be able to reissue that for 4:30 p.m. because
no, I'm not changing anything.
No, I'm only asking because friend of the court says they won't do anything to enforce that for my pickup time at 4:30 for my kids at the meeting point because Cora is in school. She gets off the bus at 3:30. It takes them an hour to drive to the meeting point.
I'm going to let this go. I'm going to let this go. And if she files the objection, bring that up to the judge.
Okay, I will.
That would have been
Thank you.
nice to know in the paperwork. Thank you. Have a good morning.
You as well.
Fucking bullshit.
Oh, don't they just love to dig that hole?